Okay, now this is a real interesting document here. This is the circuit court motion to have the case transferred from Judge Burnside right here to Judge Hutchison mentioned here. Now this is an issue because not only is it a factor that originally this was a jury trial before Judge Burnside and is now a bench trial before Hutchison, and I've never waived my right to a jury, but this was put forward by Pat Lamb. More importantly, there is no mention of it being a bench trial, so it should have still been a jury trial by this document. So this comes into the fact that I have filed complaints and mentioned Hutchison as being biased and corrupt. I have filed complaints against him with the Judicial Ethics Committee, which actually means that it's a conflict of interest for him to be over top of any case involving me, as I filed complaints against him with the Judicial Ethics Committee. More importantly, Hutchison was the judge over top the Ashley Redden case when it went to appeal, and the judge who dealt with the civil suit against Trooper Duckworth and Gary Wayne Frazier from the Public Defender's Office. Now, my right to a jury trial was requested by the Public Defender's Office for the whole 4 days they represented me, because they're not supposed to represent me where I have sued them. Now, this becomes an interesting issue. Now, here becomes a more important issue, a far more important issue. During the appeal with Ashley Redden, this was when she said that she was coerced by her mother, the prosecutor, and Trooper Duckworth. Judge Hutchison called her a liar. This here is the appeal case from the state of West Virginia, and you can see right here, Judge Hutchison. Right here's the case number if anybody wants it. The case number for the lawsuit is 07-C-710. This one is 08-MAP-4-8. Now you notice for Judge Hutchison, I was previously found guilty of 2 counts of contributing to delinquency of a minor and 1 count of battery on a police officer. Now, for those of you who know Don Rowley of the Bujin Khan, who runs around telling everyone that I pled down to contributing to delinquency of a minor from some court of inane forcible rape of a minor bullshit, which he has hollered on the internet before, this proves that he was wrong because, says I am not guilty in the form of the following. If I was pled down to this, I would not be able to say not guilty because I would be admitting to these crimes. So we know that Don Rowley's a liar, who has his close association with none other than Phil Elmore. Now, what happens is, this was brought before it, and it says, after hearing evidence presented by both parties, the court finds the defendant guilty of 1 count of contributing to delinquency of a minor and battery on a police officer. Now, the battery on a police officer thing, I admit it. I beat the crap out of Duckworth. Deal with it. And see, the court further finds the defendant not guilty of 1 count of contributing to delinquency of a minor. And again, Judge Hutchison, right there. Now, what this comes into is the simple fact that, Ashley Redden said that the prosecutor, the cop, and her mother coerced her to giving false testimony. Now, if the cop is coercing a witness to give false testimony, that invalidates any evidence gathered by the cop, including the testimony of other witnesses, because you don't know if they've been coerced by the same cop or not. The prosecutor is seeking a conviction at the extent of forcing a witness to give false testimony. It becomes an issue. Now, this right here is physical evidence that proves we need the transcripts for this case, which the prosecutor has been doing everything they can to keep us from getting the transcripts for this hearing right here. Why? Because it invalidates their claim. Now, to get more point of fact, what gets more important about this is this is a piece of evidence which was given during the first psychological examination to my forensic examiner, the counselor, or whatever, who dealt with the psychological examination in the first case and determined that he felt I was both sane and innocent. What we're dealing with is this. I had certain pieces of information, certain pieces of evidence that were on those computers, but I had copies of them stashed away with friends just in case I needed them. What happened is that knowing I had this evidence, knowing that the lawyer I had, who was doing a fantastic job, Jennifer Hewitt, I always kind of remember her name because Jennifer Love Hewitt, and she was a really great lawyer, by the way, from Fayette County. She was temporarily suspended for something, I don't know, and because of that, I was given Mingo Winters, who I fired last time, and it should have been a conflict of interest because I didn't feel he was doing his job last time for him to represent me this time. So I figured it was a setup. I went ahead and played along. The phone that was burned up really sucked because I needed evidence off of it, but it doesn't really matter because in the destruction of that phone, certain other facts came out. So we can deal with that and move on. Among these, and very, very importantly so, is this right here, where Ashley said she was coerced by Trooper Duckworth, her mother, and the prosecutor. Now, the fact that the prosecutor's office is supposed to, as per their charter, seek justice and not a conviction means they should not be coercing witnesses, and it becomes illegal and evidence tampering and in violation of their very charter, their very existence. This was brought to the example of the first examiner. This piece of information was brought to the original examiner, as well as copies of the complaints that I filed, going to the state police, recordings of me and Lieutenant Deeds, and so on and so forth. So what we have is we have physical evidence that shows the police threatening me and trying to cover things up and tampering with evidence and everything else. That forensic examiner saw this. That was the second time this evidence was brought to the prosecutor. The first time it was brought to the prosecutor was when I fired Mingo Winters, and he didn't like things I said about him on YouTube. So he requested some sort of recompense from the court. So what I did was, because he was wanting some sort of reconciliation for the court, I suppose, wanted me to take the videos down. I sent letters, a response letter to Judge Kirkpatrick. I sent a copy of this letter to Magistrate Jones, to Christine Keller's office, as well as to Mingo Winters. An hour before the trial, Mingo Winters tells me that the case has been canceled. He suddenly became sick. I went ahead and went to Kirkpatrick's office to address this, and we would have addressed the actual discrepancies in the evidence even without Mingo Winters there, just with me representing myself. But amazingly, the prosecutor didn't even show up. They had some new guy who basically didn't know what was going on. So there's me and this guy who doesn't know what's going on, and no one who can really answer questions about the case. So Winters got dismissed, and here I am. Now it gets really interesting because, you know, I mentioned that the public defender's office filed motions such as discovery and had me to sign a piece of paper saying I did not waive my Fifth and Sixth Amendment rights. All these motions they filed initially, including my right to a jury trial, for the 4 days they had me. As soon as they realized they had me on the docket, they got these motions out without even asking me about it, because you can waive your right to a jury trial if you wish to do so, but generally they only have like 20 days to do it, so they do it as soon as possible. And then if you want to waive it afterwards, you do. And I never waived it. So there's an issue there because I have a right to be judged by a jury of my peers. And I'm not getting that. And it's brought before a judge that I have a huge conflict of interest with because I have called him biased and corrupt and incompetent, if not biased and corrupt. So, yeah. And then there's the physical evidence involved in all this, which is just a complete issue. So you have people who are fabricating evidence and trying to sway public opinion by lying directly. Phil Elmore, Sam Browning, Don Rowley, who have a heavy investment in being business competition for me. But you get more to the point of fact that So the prosecutor had evidence that the police were fabricating the evidence that they claimed to have. This was even before I even knew about the missing 26 days or anything else that I didn't get from Mingo Winters, because he didn't give me anything. This is before I went to court and found out that the prosecutor's office in 2 years never filed a motion of discovery, nor general motion of discovery, nor had Mingo Winters, even though the general motion of discovery for the from the public defender's office took precedence. So it didn't really matter. And then following that, when I had the first psychological exam, I gave him a copy of the evidence. During the second psychological exam, I directed him to the internet. And so what we have here is the fact that the prosecutor has been aware of evidence showing that the police fabricated evidence, tampered with evidence, and potentially coerced a minor witness to give false testimony under oath. If she lied then why has her story changed now? Why are they going back and trying to revalidate the original case if she said that she lied? And then you combine that with the fact that Duckworth made up an FBI agent, Mike Yancek. Like I said, it's a win-win situation for me. Either you believe I talked to FBI agent Michael Hayden and threatened him over the phone because he threatened me, and I wanted him to charge me so that I would have a motion of discovery, and they made up a fake FBI agent and failed to bring forward any phone recordings because all calls to law enforcement are recorded, for the simple fact that this guy stepped out of bounds and I caught him on it and tried to trap him. Or you accept that Duckworth just fabricated evidence on top of coercing a minor witness. See, that's where it becomes an interesting little thing. And here we have it, first-hand proof right here, this little piece of paper, that shows that at the very least, one of those delinquency charges was dismissed. Now, why were they dismissed? We've heard the claims, we've heard the arguments, we've heard all the other stuff. One of those cases was dismissed. We need the ironically, we need the transcript for this, but again, we also see that it keeps coming back to Judge Hutchison. Why is the prosecutor putting this in front of Judge Hutchison unless they're trying to cover up, conceal evidence tampering by the West Virginia State Police? Why are they directly causing a conflict of interest with this whole case? Why are they attempting to illegally and improperly deny me of my right to a jury trial? If the prosecutor didn't file something to have me removed from the jury trial and make it a bench trial, then why did Hutchison put it down as such? Who in the clerk's office made the clerical error, or then in fact that Hutchison requested? We need to find all this information out, because right now, to be honest, there's a lot of questions and it doesn't seem right. Does it?